So, good day to everyone. This is once again Attorney Michelle, your instructor on criminal law and jurisprudence. So, in our previous discussions, we've actually highlighted several concepts of criminal law, especially in the development of crimes and the stages of execution. So, if you can still remember, we've discussed that generally only external acts are punished under criminal laws because internal acts such as mere ideas in the mind of a person are not punishable even if had they been carried out they would constitute a crime. So let's always remember, right, that only external acts or acts which would produce an effect in the outside world are punishable under criminal laws. That is the general rule. However, the Revised Penal Code also provides for several exemptions to the general rule. So we've also discussed those articles pertaining to conspiracy and proposal to commit a crime. So again, the general rule is that conspiracy and proposal to commit felonies are not punishable. However, under the Revised Penal Code of the Philippines, conspiracy and proposal to commit treason, rebellion, and sedition are already punishable. So those are the three crimes or felonies within which even at the conspiracy and proposal stage, they are already punishable. So during our previous class, we've already had the opportunity to discuss the definitions, the elements, and the requisites in the commission of treason, rebellion, and sedition, and what constitutes conspiracy and proposal to commit treason, rebellion, and sedition. So I hope that you will never forget those concepts, especially that they will be included during our exams. Likewise, during our discussions from previous meetings, we've already had the opportunity to discuss some of the salient provisions on the penalties or the imposable penalties under the Revised Penal Code. So today, once we start studying more about the penalties and also the specific provisions under the Revised Penal Code, we will continue to revisit what are the type of penalties that are actually imposable, especially for grave offenses, less grave offenses. We've already began with light felonies, and then now we are going upwards according to the provisions of our criminal law. So let's begin. We are now actually on Article 9 of the Revised Penal Code. So I am sharing my presentation with you guys. So for today, our topic mainly would focus on Article 9 and Article 10. And as I have previously mentioned, all the topics that we have discussed until Article 10 will be included in the exams that I will be administering on Friday. So we will be having our prelim exam on Friday. So now let's discuss Article 9. So Article 9, grave felonies, less grave felonies, and light felonies. So grave felonies are those to which the law attaches the capital punishment or penalties which in any of their periods are afflictive in accordance with Article 25 of this code, while less grave felonies are those which the law punishes with penalties which in their maximum period are correctional in accordance with the above-mentioned article. Lastly, light felonies are those infractions of the law for the commission of which the penalty of arresto menor or a fine not exceeding 200 pesos or both is provided. So let's examine each provision of this specific article. Let's start with, but before that, let us first discuss the penalties, the imposable penalties under the revised penal code. So we will also be able to imagine and also to be able to cross-check which penalties are actually afflictive, which penalties are imposable on less grave penalty. So let's first try to examine and try to remember those penalties and what do they entail. So we have the penalty of destierro. I will discuss this a little later as we go along with our discussion on this specific provision or of Article 9. We will also try to remember, okay, arresto menor is 1 day to 1 month of imprisonment. Arresto mayor, 1 month plus 1 day to 6 months. Prisión correccional is 6 months plus 1 day to 6 years. Prisión mayor, 6 years plus 1 day to 12 years. Reclusión temporal is 12 years plus 1 day to 20 years. Reclusión perpetua, 20 years plus 1 day, 40 years. And we also have here death penalty. But we've already discussed in prior meetings that currently our courts do not impose the death penalty by virtue of a special law. So we will also discuss that law today as we examine the provisions of Article 9. So let's first discuss the first provision or the first paragraph of Article 9. Grave felonies, less grave felonies, and light felonies. Grave felonies are those to which the law attaches the capital punishment or penalties which in any of their periods are afflictive in accordance with Article 25 of this code. So, let's first discuss the first sentence, okay? The first provision to which the law attaches the capital punishment. So as I've mentioned earlier, death penalty is still provided for under the revised penal code. It was not actually amended. It was not taken out. However, we do have a special law which suspends the imposition of death penalty to those persons who actually committed a crime punishable by a capital punishment, which is death penalty. So here for grave offenses, no, because grave offenses are those which are punishable by a capital punishment. So all crimes under the revised penal code or all other crimes under the special penal laws, when a capital punishment is provided, then that is considered as a grave felony. Likewise, number 2, or penalties which in any of their periods are afflictive. So although the word any is used in this phrase, when the penalty prescribed for the offense is composed of 2 or more distinct penalties, the higher or highest of the penalties must be an afflictive penalty. So there are instances actually that the offense in itself provides for 2 or more distinct penalties. It doesn't necessarily mean that for a crime to be considered as a grave felony, that those 2 or more distinct penalties should be afflictive. What is necessary is at least one of those penalties is an afflictive penalty. So under the law, the afflictive penalties include reclusión perpetua, reclusión temporal, and prisión mayor. Okay? Under the law, afflictive penalties again, no, for purposes of emphasizing this provision, afflictive penalties include reclusión perpetua, reclusión temporal, and prisión mayor. So going back to our table of penalties, so those which are punishable by reclusión perpetua, 20 years plus 1 day to 40 years. Reclusión temporal, 12 years plus 1 day to 20 years. And prisión mayor, 6 years plus 1 day to 12 years. right? So up to prisión mayor, this is still considered as an afflictive penalty. So take note of that, okay? So when we say afflictive penalty, we are talking from prisión mayor from 6 years from 1 day to 40 years. So if any of these afflictive penalties are included in the penalties provided for in a specific crime or felony, then that crime is considered as a what? A grave felony, because we also, even though it's not punishable by death penalty, the law still provides that those crimes punishable by afflictive penalties are still considered as grave penalty. So going back to my discussion on the death penalty, so as I've mentioned, the death penalty was not really removed from the revised penal code. What our lawmakers did is that what it prohibited the imposition of death penalty. So Republic Act 9346, Section 1, the imposition of the penalty of death is hereby prohibited. Accordingly, Republic Act number 8177 or RA 8177, otherwise known as the Act designating death by lethal injection, is hereby repealed. So remember our discussions before with the case of Leo Echegaray, wherein he was the first person administered with the lethal injection. So nowadays, this can no longer be done because courts are prohibited from imposing death penalty, even if such crime or some crimes are actually punishable by death or capital punishment. Republic Act number 7659, otherwise known as the death penalty law, and all other laws, executive orders, and decrees insofar as they impose the death penalty are hereby repealed or amended accordingly. So all those laws no, that impose the death penalty for certain crimes or felonies, the judge, even if the crime committed is punishable by death penalty, the judge handling such case cannot impose. So what will happen now if he cannot impose the death penalty to those accused who are already found to be guilty beyond reasonable doubt? So it is provided for in Section 2 of this law. In lieu of the death penalty, the following shall be imposed. The penalty of reclusion perpetua when the law violated makes use of the nomenclature of the penalties of the Revised Penal Code, or the penalty of life imprisonment when the law violated does not make use of the nomenclature of the penalties of the Revised Penal Code. So that's why I've discussed with you before, diba? Uh, Sometimes we get confused on the terminologies reclusion perpetua or life imprisonment. But take note, if the crime is defined under the Revised Penal Code, what we use is the nomenclature under the Revised Penal Code, which is, of course, includes the reclusion perpetua, reclusion temporal, prisión menor, prisión mayor. But if the crime is punished under a special penal law, sometimes they do not use the nomenclature used in the Revised Penal Code. Instead, they use terms such as life imprisonment. But sometimes they are considered or necessarily considered as the same. However, it's just that reclusion perpetua is based on the Revised Penal Code, while the penalty of life imprisonment is normally or usually or generally provided under special penal laws. Okay? So, Section 3, person convicted of offenses punished with reclusion perpetua or whose sentences will be reduced to reclusion perpetua by reason of this act shall not be eligible for parole under Act number 4180, otherwise known as the Indeterminate Sentence law as amended. So, while we go along with our discussion in the future, we will also tackle the Republic Act 4180 or the indeterminate sentence law. So from there, we will understand how the courts temper or decide on the penalty imposed on a criminal act, no? Depending on the, of course, depending on the nature of the offense itself, the mitigating circumstances, and of course also likewise the circumstances of the person who committed such crime. So we will also be tackling that in the future, but that is way ahead in our discussion because the indeterminate sentence law is always discussed together with the imposable penalties under the revised penal code. But don't worry, we will have an extensive discussion on this one once we reach the penalties and the imposable penalties for crimes committed. Okay, so we're already done with grave felonies. So just take note that grave felonies are those which are what? Punishable by capital punishment or penalties which in any of their periods are afflictive. When we talk about capital punishment, we are talking about death penalty. However, just take note that we have Republic Act 9346 which prohibits the imposition of the penalty of death penalty. So even if there are several aggravating circumstances for a heinous crime committed by a person, and death penalty really is available as an imposable penalty, the judge nonetheless cannot impose death penalty and may downgrade the penalty to reclusion perpetua or life imprisonment depending on the basis of the law of the law defining the crime or felony or offense committed. Okay, now let's go to less grave felonies. So less grave felonies are those which the law punishes with penalties which in their maximum period are correctional in accordance with the above mentioned article. So when the penalty prescribed for the offense is composed of two or more distinct penalties, the higher or highest of the penalties must be a correctional penalty. So example, a felony punishable by arresto minor 2 is a less grave felony because the higher of the two penalties prescribed, which is the siero, is a correctional penalty. Arresto minor is a light penalty. Okay, so let's examine what are correctional penalties. So, prisión correccional, arresto mayor, suspension, and destierro are all correctional penalties. So, correctional penalties will start from destierro to prisión correccional. So, revisiting our table here, so destierro, arresto mayor, to correctional, not including arresto menor ha, because arresto menor is a light penalty. So what is included in correctional penalties are prisión correccional, arresto mayor, and destierro. So if the crime committed is punishable by arresto mayor, prisión correccional, suspension, and destierro, they are all considered as correctional, as less grave felonies. Okay, so less grave felonies is interconnected with correctional penalties. So now let's discuss destierro. What is destierro? So I'm not sure if you've heard about this, but destierro is also a penalty provided for under the Revised Penal Code under special circumstances. So destierro means banishment for only a prohibition from residing within the radius of 25 kilometers from the actual residence of the accused for a specified length of time. While it is technically not imprisonment, it is still a penalty imposed under the Revised Penal Code of the Philippines. So what happens here is that the accused cannot live within 25 within the 25-kilometer radius from the victim. The accused here will not go to jail, will not spend some years in jail, will not be imprisoned, but nonetheless, the accused here cannot live or reside within 25 kilometers from the residence or from where the victim is residing. Okay, so it's still a penalty. So he cannot go near the victim or the residence of the victim. So from what type of cases can destierro be imposed? So Article 247, death or physical injuries inflicted under exceptional circumstances. So if you've heard about the term crimes of passion and obfuscation, this is usually the penalty where given to an accused in such crime. So under exceptional circumstances. So what are these exceptional circumstances? So any legally married person who, having surprised his spouse in the act of committing sexual intercourse with another person, shall kill any of them or both of them in the act or immediately thereafter, shall inflict upon them any serious physical injury, shall suffer the penalty of destierro. So what is this case, right? So I actually want to show you a case on this one in the future, so we will discuss that as well. So what is it in here? Okay, so if a married person catches his wife or husband having sexual intercourse with another person, and as a result of his anger of about what he saw, and as a result of that, he either kills or causes serious physical injury to the husband or wife or the paramour, okay, the person whom the wife or the husband is having sexual intercourse with, they will not actually be imprisoned. So the accused here, the legal spouse who causes the death of either or both the spouse or the cheating spouse or and the paramour, he will not be put into prison. He will not be imprisoned. He will not suffer the penalty of imprisonment, but he or she will be required to live uh, outside of the 25-kilometer radius. Okay? Okay? If he shall inflict upon them physical injuries of any other kind, he shall be exempt from banishment. So just take note that we have serious, less serious physical injuries as well. So if it's not serious physical injuries, there are qualifications of serious physical injuries under the Revised Penal Code. If the injury inflicted is not serious physical injury, then the spouse who committed or who performed the act of killing and also causing serious injury to the spouse and the paramour, then he will not be or he will be exempted from punishment. Okay? These rules shall be applicable under the same circumstances to parents with respect to their daughters under 18 years of age and their seducer while the daughters are living with their parents. So, for example, also, the parents got angry because someone seduce their daughter who is under 18 years of age, a minor, and while such daughter was living in their house. If the parents shall inflict or kill the seducer, they will not suffer imprisonment if found guilty, but will merely be penalized with destierro, which means that they will be required to live beyond the 50-kilometer radius from where the victims are residing. any person who shall promote or facilitate the prostitution of his wife or daughter, or shall otherwise have consented to the infidelity of the other spouse, shall not be entitled to the benefits of this article. Because of course, at the end of the day, if you had consent to the infidelity, if you consented, or if you had an agreement with your wife that your wife will be engaging with, or your husband will be engaging with sexual intercourse or sexual relationships with other persons other than yourself, then that will not be the act that is defined in this article. So take note of that. If you consented to the amorous acts of your wife, or if you yourself has facilitated or promoted the prostitution of your wife, your spouse, or your daughter, then you cannot raise this as a defense and still be met. And if found guilty, you will still be meted or meted by the specific penalty provided for under the law, whether it be homicide or physical injuries. Okay? So there are exemptions on that. But if the spouse, having been caught off guard, having been surprised to see his spouse or her spouse in a sexual intercourse with another person, okay, and by reason of his anger or passion or obfuscation kills the spouse, and the paramour shall not be held liable for the shall be held still liable, but will be penalized for a different kind of penalty, which is now destierro. But just take note, okay, destierro is very specific to this type of crime punishable under the Revised Penal Code, which is Article 247, death or physical injuries inflicted under exceptional circumstances. Likewise, another provision under the Revised Penal Code, Article 334, concubinage, any person who shall keep a mistress in the conjugal dwelling or shall have sexual intercourse under scandalous circumstances with a woman who is not his wife, or shall cohabit with her in any other place, shall be punished by prisión correccional in its minimum and medium period. So as I mentioned before, for concubinage, also the concubine will be what? Will be charged for concubinage. However, the penalty of destierro will be imposed to the concubine, to the kept woman. Okay? But the husband who was guilty of concubinage can be penalized with prisión correccional. It is just the concubine, even though that both of them perform the same acts and may be held liable for concubinage. It's just that the concubine specifically shall only be penalized with destierro. So take note, only in Article 247 and Article 344 can destierro be what? Be given as a penalty. For all other crimes, they are already defined under Book 2 of the Revised Penal Code. So we will try to revisit some of those crimes if we have time. We will try to see their definitions, okay, and the penalties, the imposable penalties that can actually be given for specific crimes. So because going back with our discussions, okay, criminal law is that branch of municipal law which defines crimes, treats of their nature. So now that's the nature of the crime, whether it is a grave felony, a less grave felony, or a light offense. So grave felonies, as you saw, has a different penalty or a higher form of penalty, while less grave felonies will also have penalties, but only limited to correctional penalties, while light offenses will also be punished by light penalties. Okay, next, let's go to Article 10. Article 10, offenses not subject to the provisions of this code. Offenses which are not or which are or in the future may be punishable under special laws are not subject to the provisions of this code. This code shall be supplementary to such laws unless the latter should specially provide the contrary. So, the revised penal code understands that our House of Representatives, our Senate, that will continue to enact laws, and some of them may actually be considered as special penal laws or laws which are related to criminal laws as well. So the our Article 10 provides for such an arrangement or such concept wherein just in case the Senate, the House of Representatives enact laws pertaining to criminal laws, they are no longer subject under the provisions of the revised penal code unless such law enacted actually provides that they will be subject to the revised penal code. So take note of this. This is also a very important concept under criminal laws. So examples of special penal laws, we actually have so many examples of special penal laws. And we continue to our legislative branch of the government continues to enact laws pertaining to criminal laws. For example, Republic Act number 10175, an act defining cybercrime, providing for the prevention, investigation, suppression, which and the what on the cybercrime, uh or on the commission of cybercrime. So, Republic Act number 10175. So, take note of that. I've already mentioned many times before that, again, please refrain from posting any defamatory remarks against any person in the World Wide Web or any other places in the cyber world, because you could be held liable for penalties under the cybercrime law. Republic Act number 9995, an act defining and penalizing the crime of photo and video voyeurism, prescribing penalties therefore and for other purposes. So this is more related to video recording or taking photographs of persons without their consent, especially when they are in a situation wherein or in a scandalous situation. So they also have their rights to their privacy. So if you if you take a video of them without their consent, then you can be held liable for photo and video voyeurism, even if you actually have a relationship with that person. You cannot easily take a picture of such person without his or her consent. And also, you cannot spread such video recordings. You cannot cause it to be published anywhere without the consent of such person. Republic Act number 9775, Anti-Child Pornography Act of 2009. So this is already self-explanatory. So in relation to pornography of children, promotion of pornography of children, distribution, publication is also prohibited by this special law. Republic Act number 9516, an act further amending the provisions of Presidential Decree number 1866 as amended, codifying the laws on illegal and lawful possession, manufacture, dealing in acquisition or disposition of firearms, ammunition or explosives, or instruments used in the manufacture of firearms, ammunition, or explosives, and imposing stiffer penalties for certain violations thereof and for relevant purposes. So take note again, in the Philippines, the carrying or the authority to carry ammunitions and explosives is a mere privilege and is not a right. So you must get the proper authority, the proper license before you can actually carry these types of firearms. So being future police officers, so I hope that you also know this. You are not allowed to carry any type of firearm without the proper license and proper authority. Republic Act number 9346, as I mentioned, an act prohibiting the imposition of death penalty in the Philippines. So as I've mentioned several times already, the death penalty was not removed in the Revised Penal Code. However, our laws provide that as of the moment, courts are prohibited from imposing death penalty even if the crime committed by the perpetrator or by the accused actually provides for the imposition of death penalty. Otherwise, our courts are mandated that instead of imposing death penalty, they may downgrade the penalty to correctional penalty such as reclusion perpetua or life imprisonment. We also have Republic Act 9262. This was very controversial during our discussions the last time. An act defining violence against women and their children, providing for protective measures for victims, prescribing penalties therefore, and for other purposes. So again, this law is still very effective, and I continue to remind all our men that, again, if you have any romantic relationship, if you've been married with a woman and you have a child with another woman, there are certain obligations that you have uh to also uh pursue, and of course there are certain protection provided for women and their children under this law. Republic Act number 9208, an act to institute policies to eliminate trafficking in persons, especially women and children, establishing the necessary institutional mechanisms for the protection and support of trafficked persons, providing penalties for its violations and for other purposes. An act amending Republic Act number 9160, otherwise known as the Anti-Money Laundering Law of 2001. Republic Act 9165. So this is also a very important law. We will also try to visit this. Comprehensive Dangerous Drugs Act of 2002. Republic Act number 9160. This was already amended by Republic Act 9194. Republic Act 8505, Rape Victim Assistance and Protection Act of 1998, Republic Act number 8353, Anti-Rape Law, Republic Act number 8049, Anti-Hazing Law. So if you join any fraternity or any brotherhood or any type of organization, sorority, just make sure that you're not involved with any hazing, because hazing is penalized under special law. So if you still remember our discussions on crimes mala prohibita, no? Again, good faith is not a defense. In special laws, good faith is not a defense. Republic Act number 6981, Witness Protection, Security, and Benefit Act. So this is more on the witness protection program. So actually, these are just examples of our special penal laws or laws in relation to criminal laws in the Philippines. So we will visit some of them, especially some of the important ones, of course, on the non-imposition of the death penalty, 9165, BAUSI. So we will discuss more on that as we go along on our discussion under the Revised Penal Code Book 1. So that's it for today. I hope you learned something from our discussion. Take note, we will have our exam on Friday. So be ready. I hope you have taken down notes during my lecture today. So definitely all the things that I've discussed here will appear in our exams on Friday. So I will be seeing you on Wednesday so that we can have a review, a short review of the coverage of our exams for the preliminary exams. And also, we will be conducting a recitation for all the topics that we've already discussed, beginning on the definition of criminal law. And of course, the basic characteristics of criminal law. Please do not forget those concepts because they are very important principles, and they will continue to appear as we go along, as we try to understand criminal laws in the Philippines in the future. So thank you so much for today. I hope you will do well on your exams. Do your best, study well. The exam will be difficult. I will make sure that it's going to be difficult because I want you to prepare. I want you to be prepared for your other exams. So make sure that you are always taking down notes. Make sure that you are always listening and attentive during our discussions, and make sure that every time we meet in the Zoom meeting that you will always participate in the discussion and in the recitation, so that if ever your exam results will not be as good as you would expect, then your recitation and your participation, your attendance may be able to augment your grades for the semester. So anyway, this is Attorney Michelle. Thank you so much for listening today. I hope that you will have a safe and healthy day, and see you on Wednesday for our review. So good evening, everyone. Stay safe and stay healthy.